Hello friends, how are you? Today I am going to discuss an important topic of anticipatory bail under section 13 subclause 1 subclause C with section 13(2) of the Prevention of Corruption Act with section 420 and sections of forgery as defined under the Indian Penal Code. Friends, usually when we move the bail we got confused that on what parameter we should move the bail so that we could easily get the remedy. Friend, this video is for the South Indian people and for those people who understand English. The English version, Marathi version, Gujarati version, and apart from that the Hindi version is also going to be recorded on the same track so that the concerned person of the concerned region could understand the law in their own language without any difficulty. Friends, now we are coming on the point. Section 13(1)(c) inter alia define the punishment wherein the basic allegation against the public servant is that he is involved in the activity of embezzlement of the concerned public funds. And apart from that, the sections of forgery and 420 is usually imposed because the prime allegation is that the offence is not committed by abusing the official position but also in consequence of the official position the false document has been prepared with intention to cheat the exchequer. Exchequer means the concerned government. So whenever we are going to plan to move for the anticipatory bail application, we have to consider certain points so that we could easily argue our bail application and could be the best pleader in the court of law. This video is quite important for those persons who are young advocate and about to come in the field of economic offences, for those who are suffering the case of the Prevention of Corruption Act and yet they have to move the anticipatory bail, and for those who want to learn about the prevention of corruption, about the economic offences and the matter connected therewith. So topic is very much important. Now I am going to start the presentation, but the video is not the outcome of my own discretion, of my own thought, rather than it is based on the judgment of Honorable Patna High Court. So video is quite important. Please be seated, keep a copy with you along with a pen and note down what I am going to narrate to you so that you could be an efficient pleader, an efficient litigant, an efficient person in term of knowledge. So let's start the presentation. Friends, the facts are that the petitioner apprehends his arrest. Please note down what is the meaning of apprehend. Apprehend means the type of apprehension. It is a type of fear in the mind of the concerned person who is accused of an offence. We are moving the anticipatory bail. We have to convince to the Honorable Court that the offence is not committed, it is a false offence, and inter alia the concerned IO want to arrest us with intention to humiliate us. In that scenario, the provisions has been incorporated in section 438 of CRPC. So this is a basic requirement of moving the anticipatory bail. You have to apprehend the false arrest in a false case. Got the point now? Very easy. In the present case at hand, the accused has been booked for the offences punishable under section 406, 420, 409, 467, 468, 471, 472, 120B and 34 of the IPC. In these sections, the maximum term is of life imprisonment. Specifically, I am emphasizing on section 467. And apart from that, after 467, section 409 prescribed the maximum punishment of imprisonment, and apart from that, the remaining section prescribed a maximum sentence of 7 years. Easy now? Got the point. And apart from that, section 13(1)(c) and 13(2) of the PC Act is also incorporated with section 66 subclause C and 66 subclause D of the IT Act is also imposed on the concerned accused. Very easy to understand. The concerned petitioner has moved the bail application. He submitted that he is a clean person with no criminal antecedent. That is a very important point, because when you are moving the bail, you have to convey to the court that you are not having a previous criminal antecedent and you are having a very clean image in the market and you are a reputed person. As far as the complaint is concerned, the allegation of informant is that the land of particular person pertaining to khata number, khasra number, area was acquired for stabilizing Mahatma Gandhi Central University at village. The prime allegation subsequent to this is that thereafter means subsequent thereto, Mr. Sukhdev with all relevant document appeared before the concerned authority for the purpose of compensation of the sentence, because when the land is acquired as per the protocol of land acquisition act, you know that there is a protocol for the compensation and is to be awarded to the person of whom the land has been acquired, and inter alia it is taken up for the certain purposes. In the present case at hand, a particular amount has been computed for the purpose of compensation. and the said amount has been transferred in the concerned accounts of Dena Bank from PD account number so and so of Treasury. It is alleged that thereafter another person disclosing his name as Sukhdev appeared for receiving compensation. Thereafter, on inquiry, it is found that the amount of compensation has already been awarded and given to the concerned person having the same name. And thereafter, it is revealed that from the account of Dena Bank in which the money was transferred from PD account number, an amount of so and so was transferred in the account of J. Kishun, an amount of 70 lakhs was transferred in the account of Arvind Singh, and it is thus alleged that the said amounts has been embezzled. The concerned counsel for the petitioner further submits that the petitioner is a circle officer and has been falsely implicated in the case. It is submitted that he is not named in the FIR. His name transpired during the course of investigation. There are certain circumstances in which the accused is not named, but in the course of investigation, the particular person. Another argument is that the petitioner is a circle officer. He is falsely implicated in the case. He submitted that he is not named in the FIR. There are certain things. For example, the accused may be named in the FIR, may not be named in the FIR, but in the course of investigation, he may be named. But thing is that the investigation agency should specify that the allegations are specific, it is cogent, without any manipulations, and evidence should be admissible as per the protocol of Indian Evidence Act. But in the present case at hand, he has been arraigned as an accused on the basis of confession statement of the co-accused who is in police custody, and that's why by the virtue of section 24 of the Indian Evidence Act, the same lost its evidentiary value. And apart from that, in the course of investigation, the name of the petitioner does not transpire, but his name transpired in the supervision report of the concerned DYSP. So the evidence is totally a weak piece of evidence, and there is no direct role of the concerned accused in the alleged crime. He submitted that the land possession certificate number 3474139 issued from the office of petitioner, and during investigation it has come that the alleged LPC means land possession certificate number is issued from the office of petitioner, but in other certificates means certificate number 74139 the signature of petitioner appear as similar, thus was recommended for examination by the handwriting expert. So whenever you are having a dispute that your sign has been forged, you are falsely implicated, then do not be lazy in your approach. Immediately file the application before the concerned police or investigating authority for the forensic examination, and the provision regarding the same has been incorporated in section 45 of the Indian Evidence Act. And apart from that, the section specified for the opinion of court, but the police is bound when you are raising a doubt on the concerned handwriting or signature that it is not of you, then they are bound for the forensic examination, and the report of the forensic expert is to be obtained as per the protocol of section 293 of CRPC. Although the Honorable Supreme Court has specified in Catenov judgment that the handwriting expert should be examined to prove that report. If the concerned expert is not examined, the report could not be proved. Okay, now, so these are technical points which should be kept in your memory, so that when you are contesting the case, you could easily fight without being misguided. And apart from that, without waiting the report of the handwriting expert, the petitioner has been made an accused in the present case. So that is a very clinching point, because usually the agency under pressure act and inter alia implicate the concerned accused without waiting for the result of the concerned experts. Usually we see that in the case of voice sampling, the FSL is yet to come, but they implicate you as an accused. And another example is that in case of forgery, the handwriting expert report is quite essential whenever you are going to raise the claim that the sign is not done by you, the writing is not of you, and it is totally disputed. In that scenario, the handwriting expert report is sine qua non, and in the present case, the allegation of the defense is that without waiting for that report, they want to implicate the accused in the present alleged crime without any basis. The submission is that he is a government servant, he will cooperate in the investigation, and apart from that, he has cooperated, already joined the investigation. So that is a very clinching point, that how he had joined the investigation, because merely admitting the fact is not sufficient. You have to show the same as per your special knowledge by the virtue of section 106 of Indian Evidence Act. In the present case at hand, the concerned accused specified that he inter alia went to the concerned agency to cooperate. To show the same, do the following thing. Number 1, just give the notice with all the facts to the concerned IU. Number 2, submit the representation It will clarify the stand to the court that already you have submitted certain things, but the IO is not willing for the same. Number 3, move to the higher authority with a prayer for fair investigation, even move to the concerned court. And subsequent to this, if necessary, move for the anticipatory bail or for the question, but without which, if you are moving, you would not be in a position to convey the court, because they are having the FIR, charge sheet, other things against you. What you are having? Nothing else. By mere argument, you could not be rescued from the clinches of law. So try to be prepared yourself, act in clever manner, be legal and lawful while doing the argument before the court of law. The contention was that the accused has not been arrested for a considerable period of time. If he is arrested inter alia, it will affect the basic rights of him, because the right to get the protection from illegal arrest is also a fundamental right, as enshrined in Article 21 of Constitution of India. And apart from that, his submission is that no useful purpose will be served if he is sent to jail, because already investigation has been done. Nothing is to be recovered, nothing is to be investigated. So court, while considering all the facts and scenarios, submitted that the petition named above, in case of arrest, will surrender before the London trial court within the period of 6 weeks. Considering the submission of the concerned counsel, the court inclined the bail application and released the accused on the anticipatory bail on furnishing of the bail bond. So these are the important clinching points which you are required to be remembered in your mind. Friends, whenever we are going to move the bail application, just make out a proper brief, just do the proper research and try to convince the court that you have cooperated, and already you have provided all the material information, but the IU is not willing to cooperate you, he is not willing to investigate on your facts and inter alia want to implicate you. If your facts are totally convincing, if you have shown that investigation is not pending, there is no need for any recovery, you are not required for any custodial interrogation, and the same is confirmed by the agency also, it will inter alia boost up, it will inter alia sustain your stand. But apart from that, by doing the independent argument, you convince the court that it is not the case that I have committed the crime, because if there is no direct involvement, you are involved indirectly, there is no allegation against you that you have cooperated or you have conspired, and apart from that, there is a flimsy allegation or allegation on air against you. In that scenario, you could easily claim the bail remedy. So be assured, whenever you are going to move, that you must be confident in terms of fact, law and other scenarios. So friends, it is a very good video concerning the rights of the defense. And remember one thing, I am not the prosecution counsel, I am a defense counsel. My work is to enlighten you about your right, so that our fight is against the false prosecution. I want that you should be ready, you should be willing, and you should be with a great energy, with a great legal position to fight with those false prosecution. Friends, this is an important legal update. For such update, please subscribe and like my page, my channel. Friends, see you in the next video. Till then, Jai Hind, Jai Bharat.